Supreme Court in the matter of DHIRUBHAI BHAILALBHAI CHAUHAN versus the state of Gujarat allowed the appeals impugning a common judgment and order of High Court of Gujarat at Ahmedabad dated 5 May 2006 passed in Criminal Appeal 155 of 2016 whereby High Court though maintained the acquittal of 12 out of 19 accused who were put on trial partly reversed the judgment and order of acquittal passed by trial court in sessions trial number 119 of 2003 and convicted appellants for offences under sections 143, 147, 153A, 295, 436, and 332 of Indian Penal Code and punished them with varied sentences, all to run concurrently, maximum being of 1 year. The impugned judgment and order of the High Court was set aside, and the order of the trial court is restored by the Supreme Court. The prosecution case, founded on FIR report lodged by PW1, a policeman, was to the effect that on 28 February 2002, while informant was patrolling with other police personnel, information was received at around 10:10 that a mob had surrounded graveyard and a mosque at village Wadud. When the police party arrived at the spot and instructed mob to disperse, mob pelted stones, causing damage to police vehicles as well as injury to police personnel. In consequence, police had to take recourse to release of tear gas shells and firing of gunshots, which resulted in stampede-like situation. In the melee, the police could apprehend 7 persons on the spot, namely Dhirubhai Bhailalbhai Chauhan, Maheshbhai Bhailalbhai Chauhan, Mukeshbhai Ambalal Patel, Kirtibhai Manibhai Patel, Rajiv Bhai Harman Bhai Patel, Deepak Kumar, Bhopal Bhai Negi, and Sanjay Kumar Lakshman Singh Mahida, all residents of village Vadod. Investigations resulted in charge sheet against 19 persons, including the ones who were arrested on the spot. Based on charge sheet, cognizance was taken, giving rise to session trial. Supreme Court said that in cases of group clashes where a large number of persons are involved, an onerous duty is cast upon the courts to ensure that no innocent bystander is convicted and deprived of his liberty. In such type of cases, courts must be circumspect and reluctant to rely upon testimony of witnesses who make general statements without specific reference to accused or role played by him. This is so because very often, particularly when the scene of crime is a public place, out of curiosity, persons step out of their home to witness as to what is happening around. Such persons are no more than bystander, though to a witness they may appear to be part of unlawful assembly. Thus, as a rule of caution and not a rule of law, where evidence on record establishes the fact that a large number of persons were present, it may be safe to convict only those persons against whom overt act is alleged. There may, however, be a situation where a crowd of assailants who are members of unlawful assembly proceed to commit murder in pursuance of common object of that assembly. In such a case, any person who is member of unlawful assembly is equally liable, even though no specific overt act of assault is attributed to him. Otherwise, also, where assailants are large in number, it may not be possible for witnesses to describe accurately the part played by each one of them. Besides, if a large crowd of persons armed with weapons assault the intended victims, it may not be necessary that all of them must take part in actual assault. Therefore, in a situation like this, what is important for the court is to determine whether the accused put on trial was a part of unlawful assembly or just a bystander. In the instant case, appellants were residents of same village where riots broke out. Therefore, their presence at the spot is natural and by itself not incriminating. More so because it is not the case of prosecution that they came with arms or instruments of destruction. In these circumstances, their presence at the spot could be that of an innocent bystander who had a right to move freely in absence of prohibitory orders. The suggestion given by the defense counsel to investigating officers during cross examination that accused were trying to douse the fire when they were apprehended, though might be useful to confirm their presence at the spot, cannot be used to infer that accused were part of unlawful assembly. Court said that in absence of any inculpatory role ascribed to appellants, their arrest on the spot is not conclusive that they were part of unlawful assembly, particularly when neither instrument of destruction nor any inflammatory material was seized from them. Besides that, the police resorted to firing, causing people to run helter-skelter. In that melee, even an innocent person may be mistaken for a miscreant. Thus, appellant's arrest from the spot is not guarantee of their culpability. Court said that in our view, therefore, mere presence of the appellants at the spot or their arrest therefrom was not sufficient to prove that they were part of unlawful assembly comprising of more than 1,000 people. The view to the contrary taken by High Court is completely unjustified, more so while hearing an appeal against an order of acquittal.